And a large part is often the inability, because what people forget, and the DOJ report does use a very important phrase. It's called the police culture. It's sort of a worldview or a paradigm that those officers and the chief officers are being culturated or inculturated in, both through the formal and, more importantly, the informal training processes. And oftentimes they can't see outside that box, and that becomes a real problem. And just to add to, I mean, I think it's very important to keep stressing that word corruption, because it offends public agencies and officials to no extent, and it ought to. It ought to shock them into saying when we're doing something wrong. And there's two types of corruption, and usually one breeds the other. One type of corruption is what people really take personal offense to, because they think I could never do it, is where you're claiming someone is individually morally corrupt. They're doing something for wrong reasons. There are instances of people in government positions, including police, who do that. But that's not the only corruption. There's also systemic corruption. There's a corruption of the process, of the institutions. And just like when you talk about, with computers, a corrupted hard drive. Well, what do you do when you have a corrupted hard drive? You have to replace the infrastructure to get rid of the corrupted problem. And until you can get that corrupted system, fixed, so that that's not at the foundation, you're going to have a hard time dealing with the other individual level of corruption. And so I think it's really important, as you did say, to stress that yes, corruption is the word, and it should not be deemed an inappropriate word. It is the proper word to deal with this kind of thing when you think about it from a legal and political sort of institutional perspective, because the institutions and the processes that are there in place, if they were followed according to the letter of the law as it exists right now, even with the ability to point out flaws, most of these things would not be tolerated. And yet, systemically, they are being tolerated, which, of course, the Boyd shooting really brought out to light when the chief of police came out the next day and did something very predictable in the national police culture and said it was a justified shooting. Now, anybody looking at that video with no other information can clearly see that it's not. And I don't think what a lot of people know, and the chief used a case law he cited, which is Tennessee v. Garner.
Case.
And when I heard that, with my background in law, I said, whoa, how is this case? Because that's a case where the United States Supreme Court declared a Tennessee law that said any use of force, deadly force by a police officer, simply because he claimed to fear his life, was justified. That's what the statute said. And that was declared unconstitutional. And the entire case is about a case where police officers who were justified under the state law were declared to have acted unconstitutionally and unlawfully. And when I just couldn't wrap my head around how, and clearly the chief did not get this from his own legal research. It was given to him by somebody. And it was just random that someone sent me a case from Georgia. And I was reading the case, and it was another one of these cases where it declared the officer's actions wrong. Where, officers were in a backyard of a homeowner, and he went outside with a shotgun thinking that and you've got these all masked men in black, camouflage, and they shot him for having a shotgun. Which, he was out there thinking that someone was invading his home. And it was declared this was a wrongful shooting. But there was a footnote to that. And I didn't originally connect it to the Garner case, but I said, of all of this case, This footnote is troubling because what it does say is, be careful though, just because an armed suspect doesn't necessarily act in the way of aiming and about to shoot doesn't mean that the officer doesn't have reasonable fear. There are other, but the rest of the context says it's the whole context, what's the offense? Is it a violent offense? Is this person about to, likely commit another violent offense if you don't capture them that day? Otherwise, let them go for one day and get them tomorrow. There's no urgency to the point where you have to shoot someone dead just because they haven't fully complied. And compliance is something we might want to talk about. I don't know if you've got anything, if you've heard this word, but that it was that footnote which was a reference to Tennessee v. Garner, which was merely saying, don't take our statement, too far. And it just seems like that footnote may be what they're latching on to. But it's not. You're a lawyer. You know how case law little snippets can be manipulated. And the fact that the national police culture and the national police leadership is not stopping those misuses of the law becomes a problem. And the fact that the local city government takes these statements as authoritative without actually looking into them or questioning them, and not a single journalist went and got that case law and said, well, how in the world can you apply this case to the Boyd shooting and claim it's justified? It makes no sense.